Good morning, everyone. All right, I was trying to come up with a topic to share with you guys today, and I was like, okay, what do I want to talk about? And I had a series of phone calls that week, and it was all like stuff that people were finding out at the last minute, like right before closing. And of course, that's like panic time. And I always want to be able to come up with an answer that resolves it and you get to go. And every once in a while, unfortunately, sometimes I have to say, give bad news. So I was like, all right, so how do we avoid that kind of situation? So that came up with my topic, my thought. And then I was like, well, now I gotta name it because I don't want to just be boring, right? So I was like, all right, what do I want to name it? And so my husband and I kind of have this like pet peeve, if you will, about people who are what we consider to be fake Southerners. So, maybe a race car driver who won't be named who was, from California. Or, in this particular case, what about a country music singer who y'all has the most country accent ever, but he's from California. So he sings about heartache medication. And I thought, all right, that will be the name of our, uh-oh, it's not working. Oh, there it is. Okay, there we go. So now John Pardee, who has, sings about heartache medication. And in this particular case, last year when I spoke to you guys, we did the ethics presentation over Never Have I Ever. It was a drinking game. So we're not going to do that today. But obviously, a lot of the situations we talk about today make us want to turn to alcohol. So I figured it was better if I started at 10 this morning rather than if I did the 1:30 and we might actually start drinking. So all right. So again, my thought process for today was basically give you guys some tips and things so that should you find yourself in a situation where you've got that last minute heartache situation, maybe you've had we've given you a little bit of a cheat sheet, if you will, to avoid the stress that goes with that. Forewarned is definitely forearmed in this situation. All right. So real life example. You have a deal. It involves a loan for $4.5 million. The land is 5 acres and it is not a construction loan, right? So you have a lender who says they won't survey coverage and you're happy, right? Because can't speak for all underwriters, but most of us have a process in place that says we can give survey coverage to a lender as long as the property is less than 25 acres. It's not new construction and the loan is less than 5 million, right? So you're sitting pretty, right? No issues. Except the day before closing, you get their closing instruction letter and they have a list of endorsements that they must have. And they've asked for the 8.2, the 9, the 17, the 22, and the 25. Now, show of hands, who in here has the numbers memorized, by the way? No? Yeah, okay. All right, so sadly for me, I do, and we are all the way up to 50 Alta endorsements now, and I've had to expand my brain more and more. So at some point in time, I'm going to start forgetting what they are, but hasn't happened yet. So 8.2, environmental, we don't care. But the 9, the 17, the 22, and the 25, well, they're survey-related endorsements, and you don't have one. And it's the day before the closing, right? Well, what are we going to do, right? So first of all, the 17 is your access endorsement, right? So if you don't have a survey and they've demanded they have an access endorsement, do we have a platted legal possibly? Because if we've got a plat, it's going to show access points, right? And so if you're really lucky, your underwriter will probably say okay on that one, okay? So that's one possible piece of medicine that would help resolve the issue. But if you're asked for a 22, the 22, what does that do? That's the location endorsement. So location endorsement says we are ensuring that you have a office building located at 6060 Poplar, right? That's what the location endorsement says. Well, typically we require a survey to tell us that. We don't on residential. So if it's a residential transaction, no worries, right? But if it's commercial, how are we going to prove, what evidence do we have that we have a structure located at a specific address? Well, maybe the tax assessor's records might have that information, right? So maybe we've got another way that we can fall into the 22. But the 25, anybody know what that one is? It's the same as survey endorsement, right? You don't have one. So why are they asking for it? So I've done another presentation on my love of endorsements and why they end up on people's lists when they don't need them. And I've used the picture from The Princess Bride and the scene where the guy says, "I do not think it means what you think it means." That is absolutely the case when a lender is discussing survey coverage. When they say they need survey coverage, we assume they mean they want the deletion of the survey exceptions, right? So the survey exception, the generic survey exception, we all put in our commitments. And occasionally there's like an easements and, things not of record, that kind of thing. So that goes with our survey exceptions. So again, less than 5 million, less than 25 acres, not construction, we can take those exceptions out without a survey. The lender gets survey coverage, right? But the underwriters at a lender, so not to be confused with title underwriters, but the loan underwriters, they have just enough knowledge of title insurance to be dangerous. And they go through that list of Alta endorsements and they see that it's a survey. So that means they need survey coverage. So that's the endorsement they need, right? All right. So typically, when you call them back and you say, well, I see that you've requested the 25 endorsement. Was there a survey? Because we didn't receive that. And they're like, no, we don't have to have the survey. Okay, well, if you're not requiring the survey, we can give you survey coverage by deleting the survey exceptions. We can't give you a 25 endorsement because it refers to a survey. And they're like, oh, okay, well, but wait, what does that mean? What am I not getting? Because I need to know that my legal description is good, and that's what the survey does, right? So that's my other pet peeve about the survey exception, or the survey endorsement. Survey endorsement was created to say that when your vested deed legal is different than the surveyed legal, because surveys get better and more accurate with increases in technology, we were ensuring the insured that the properties were the same, even if the description of the survey and the description in the vested deed were different. That is why it's a same as survey endorsement. If your vested deed legal and your survey legal are the same, do they need the same as survey endorsement? No. Do they want it? Yes. Doesn't matter if you give it to them. No, you can give it to them. It's fine. There's no risk. They just don't need it. So if they're desperate for survey coverage, what they really need is the deletion of the survey exception, which we have agreed to do. So don't panic. There's no heartache involved if you get this situation, as long as you're following into all those others. Occasionally you will have someone who says, but it's on my list, right? Send them to me, send them to Darren, we'll take care of them. So, all right. Other issues with legal descriptions. So I always share my stories with you guys, but I never tell you what state it's in or who did it, because I'm never going to put somebody on blast like that. But I got a call about a week ago from a national agent out in Washington State that was working on one of those like Quicken loans, right? So we don't really like them. They take business from us anyway, but they call because they had a situation in one of my states. And they said, we're working on a refinance for this customer, and we think there's a problem with their legal description. And we're just wondering if you could tell us what we can do to resolve it. I said, okay, send it on. So I pull it up and I look at the deed, the loan document. And in all caps, in front of the legal description, it says questionable legal. And then it's a quarter section of a quarter section, section, township, and range, less than except a 1.5 acre tract. And then at the bottom it says, seek underwriter approval. And all of that was included in the legal description for the documents that got recorded, right? So I was like, well, yeah. And okay, so a quarter section of a quarter section would be 40 acres, right? So less than accept 1.5, we've got 38.5 acres. The property that was supposed to be conveyed in mortgage was a 1.1 acre tract. So yeah, we got a problem, right? So nobody read the legal description before it got put on the deed, and nobody paid attention that the search, I guess, kind of, whatever good person examined title noticed there was a problem and tried to tell everybody else, but nobody else caught on to it, right? So now we got to fix it. So that would definitely fall into the category of a little bit of heartache medication, right? Because that's not necessarily something that can be resolved really quickly. Um, One of the other problems that we have seen recently is beginning points. So if you're not lucky enough to have a section of a section of a section, and you actually have to get into the weeds, as we will, if you've got one that says beginning in a spot in a road, probably not your best legal, right? Because you want your legal description to actually have a finite beginning point and a finite ending point. You can probably get comfortable with some of the missing pieces in the middle as long as you got a good place to start and a clear place to end. If it tells you that you begin on the shores of the lake, what lake? Where on the shore? You got some issues, right? So with surveys, keep in mind when you're issuing a policy, right? Our policy is supposed to be ensuring the insured, whether it's a owner's policy or a loan policy, that they have a specific interest in a defined piece of property. And even if they have a policy with a survey exception in it, we're still not doing them a favor if they don't really know what they have. Case in point, when you get a legal description and it has less than accept, less than accept, less than accept, less than accept, and you have 6 or 7 or 8 exceptions out of the legal, does your lender really know what they're getting? I mean, and if they're making a loan on a per acreage or per square footage, I mean, how do they know what they're actually getting, right? So if you have a situation like that and you get a response back from an underwriter that says you really need to get a survey, it may not be the final point, and we may be willing to work with it, but we may have to come up with more exception language. So that's another thing. When you get into a situation sometimes at the last minute and you don't have what you need, we may be able to work out a solution that allows you to go ahead and close, but you're going to have additional exceptions that might have to address the situation, and then you have to be the one to explain that to your customer in a way they understand. And we've had discussions about that before, where a lot of times the customer says, oh, it's fine, you just put an exception in there, I'm okay with that, but they don't know what that means, right? So you got to remember to do your due diligence and take care of your customer. All right, so scrivener's affidavits, right? So the fun thing about scrivener's affidavits is they do cure a whole lot of ills. So they could certainly be a rescue medication for you in a situation that shows up at right before closing. But they're not the be all end all. So what we see a lot is, case in point, my situation that I just shared with you guys, where the 38.5 acre description, the agent that was involved, without working with an underwriter at all, recorded a scrivener's affidavit and swapped out the questionable legal for an actual description of the 1.1 acre that was supposed to be conveyed. You all think that works? Right, so scrivener's affidavits are supposed to address a clerical error, a typographical mistake. Swapping legal descriptions, probably not necessarily a clerical mistake, right? It's a bit different than that. Now, I will say, what if it's a completely different property altogether, right? This 1.1 really did come out of this 38.5 acre tract, which the grantor did actually own, right? So there is a question of intent what was supposed to be conveyed at this point in time, right? But if you don't have that, if I never owned Oaklawn Casino ever, but I owned a business down the street and I convey you Oaklawn Casino because somebody made a mistake on the search or made a mistake with the legal description or whatever, possibly maybe you can make an argument that that was a cut and paste mistake, a clerical error. But it would take something like that. And you would really have to work through whether or not, again, is that going to clear title for your customer? Is your insured never going to have an issue with that moving forward? Is someone going to use that mistake as a reason not to move forward with the purchase of the property? Or maybe the lender says, I don't feel good about this. I don't think my security, oops, sorry. I don't think my loan will be secured. And you need to go back and make a curative measure. You need to go back and get a new deed or whatever it might be. So you kind of have to factor those things in when you're deciding it. But the key to remember with the Scrivener's affidavit is that it's supposed to be addressing minor typographical mistakes. If whatever the change needs to be made impacts the intent of the document, you're really not supposed to use the Scrivener's affidavit. So, and if you have a question about that, always reach out to your underwriters. So, and at this point in time, you may or may not feel like you want to pull your hair out, but that's okay because we're all going to get through it. It's going to be fine. We'll figure it out. So, all right. Everybody love the unreleased contract for deed, right? Don't you love when that shows up in your chain of title and you have to address it? Or more recently, we've had a rash of people recording their purchase and sale agreements because the seller decided that they got a better offer and they wanted to go with someone else. And so now these have started clouding up our chains of title, right? Often when that shows up, and sometimes you may not find out about it until right before closing, we get those calls, we get those emails, right? And there's a lot of frustration, I think, around those because there are some valid reasons why you might feel like you don't have to deal with it, right? You may feel like, look, this was a contract for deed and it was 15 years ago and they never took title and now they're selling it. But why do you think that we as the underwriters have some concerns about that? Why we tend to be a little hesitant? Okay. Well, first of all, how well do you know your customer? How well do you know that contract for deed that was that was of record 15 years ago? Well, maybe that buyer in that contract has been paying their payments and been on site for 13 of those years, right? And then for whatever reasons, maybe they did fall behind or something. If they've paid on a contract for deed for that long, they have built up equity in that property that arguably they may have some right to claim against, right? So there's a litigation risk for us. So we have to get more detail. It's not enough to know that that contract of deed has been of record for a super long time and there was never a deed. We got to get some information. How long were they on the property, right? How long did they pay under the contract? If they've been gone for 12 years, well, yeah, we're probably good. We'll ignore it. But if they have been there up until recently, that's when we start needing some more information. Okay. And keep in mind some of the other things. Once they've built that equity up, what if, because they have fallen behind on their payments, and maybe they've only been behind their payments for 9 months or so, and the seller says, you know what, I'm done with this. Our contract says if they fall behind, I can sell it. That's what I'm going to do. And then the buyer runs and files bankruptcy, right? There could be a claim for the bankruptcy trustee with respect to some of the equity that's been built up in that property. They don't win. But again, for our purposes and ensuring over that, we've got to have all the pieces of information to make sure we're protecting the insured against having to be drawn into any of that mess. So that's why we are not as it's easy maybe to convince that it's not a big issue and we can insure over it. So it comes down very much into a fact-specific situation. The purchase and sale agreements and the folks that are recording those, that kind of is in a different bit of a category. And I don't know if you've seen much of those in your areas, but for those of you that have, a little bit of it started during the aftermath of COVID, when it was a fabulous seller's market and people were bidding way over the contract price, and some of the sellers were like, well, forget that. I don't want to take that offer because I got another one today that was, 10,000 more. I want to go with this one. So some people started recording their contracts. We're not in that market anymore, but what we have now are these lovely We Buy Houses. And there are all these investors, these real estate investment trusts that are from all over the country that are coming and buying property in our area. And they tend to go to areas where maybe they're not the most sophisticated folks, right? And so they tell them, hey, we'll buy your property. We'll pay all the closing expenses. We got this. But they're not really giving them fair market value, right? They're usually coming in significantly lower. And most of these unsophisticated folks don't really maybe necessarily know that they're getting rooked. But what happens is, post their entrance into this contract with the We Buy Houses or whatever folks, somebody educates them. And so now they want to get out of that. And so they ride it out, and for whatever reasons, the closing doesn't happen on the designated closing date. And it could be because the buyer in this contract didn't get their act together. But in any event, once the closing date runs, the seller goes and gets a new contract with somebody else for a better price, and they want to close. So the buyer in the first one says, oh, no. And they go around and they record the contract. But now there's nothing in the contract about a termination date. So what ends up happening is when the seller finally does find a buyer that they want to go forward with, title company comes back and says, well, you got to get a termination of this. You got to address this, right? Because it's a risk. There's someone who claims to have an interest in the property under a contract. What are we going to do about it? And these enterprising companies will say, well, I'll terminate it, but you got to pay me a fee. And some of these companies are charging outrageous fees. And in some cases, it's a scam. So some states have passed some legislation to attempt to deal with this. If it's not a huge problem in y'all's area yet, just be on the lookout for it. It may be coming. But that would be something to possibly be looking at in the future. This is a relatively new thing, so we've got, I don't remember now, last count, there's at least a handful of states that have passed legislation that will go into effect this year, attempting to address this. And it varies as to how they're trying to take it on, but some of them are at least trying to put like a termination, right? It can only be good for so long. You've got to put a termination date in. So we'll see how that works. And they're requiring buyer and seller to sign off on the recording and some other things. So they're trying to prevent the fraud that's happening with those. All right, so we talked about all that already. Okay, so back onto my lovely endorsement situation. So we're seeing more and more West Coast lenders make loans in our area. And they are working these poor little residential loans to death. And they're sending in requests for 10 or 15 endorsements on a $175,000 residential loan, right? And, again, we talked a little bit earlier about the fact that you might not need all of the underwriting things for that. But one of the things that is sometimes a little bit of a heartbreak is when they ask for the Alta 9, right? So it is a very, very fabulous endorsement. And on residential, almost all underwriters agree to the 9 can be included. But one of the things that kind of gets lost is the fact that the 9 includes mineral rights coverage, right? So on a residential property, we're not concerned about a risk of there being an issue as somebody, exercising their mineral rights. But on commercial, it's a different story. So typically, most of us aren't doing mineral searches on every transaction that we do, right? But that Alta 9 gets requested on darn near every transaction that we do, right? So just a little hint that the bigger transaction you have, don't be surprised if there does become a request from the underwriter about some information regarding the mineral rights, right? Where is this property located? What's the mineral activity in that county? We may have to ask some additional questions on that one. With the utility access, that's a 17.2. That is a very popular one. It's beginning to show up on a lot of those residential ones. Don't panic. We're not going to require a survey on that one either. Mostly, we just want to make sure, did your seller or the tenant or anybody have any concerns about not having access to any utilities? If that's been an issue, we need to know about it. Otherwise, you're good on that one. Contiguity. Anybody know what that word means? All right, so I will tell you that it is misspelled 80% of the time. I will tell you that probably 95% of the time it doesn't apply. That endorsement is an insurance from us to the insured that says, we're insuring you in the event that parcel A is not contiguous to parcel B along the west line or the north line or the south line, whatever it is. So what would that entail? You got to have at least 2 parcels, right? So it shows up on darn near every list, and you have 1 parcel. So what are you contiguous to? And when you ask them, they don't have an answer. But what they always will tell you is, but it's on my list. We always get it. It's on our list. It doesn't apply. So I'm on a one-woman campaign to try and get the words "if applicable" added to this dumb list that all these lenders have. I'm not successful, but I'm determined before I die that it will be there. We talked about the same as survey before. Easement encroachment. So I'm going to jump ahead on some of these slides because I want to talk about the encroachment situation. So often that is something that does come up towards the very end of your closing time, right? If you did have to get a survey, maybe it doesn't show up until a day or 2 before closing. And now you've discovered you've got some issues, right? Because one of your improvements is encroaching onto a utility easement, or maybe it's encroaching over the building line. Maybe it's encroaching over the actual property line. You never know what you're going to find on some of these surveys. So we have sort of, over the years, built a little, okay, what's our level of concern, right? So often with a setback line encroachment, we're going to say, how long has this improvement been there, right? If this is something that's been there for 20 years and no one's ever said anything about it, we'll probably tell you it's fine. You don't have to worry about it. Or if you've got a encroachment into a utility easement, we're gonna find out, like, okay, how big is it? If we're only encroaching into a small piece of this utility easement, then it's probably not impacting their ability to service the line. We'll look at it from that perspective. And so that's the miracle of the 28 endorsement, because it just basically allows us to insure the insured against enforced removal, loss, or damage associated with that encroachment. So that is a really popular endorsement. Again, when I was talking about the Alta 9, it's in that endorsement already. So there is already endorsement coverage in the 9 for encroachments over building setback lines and utility easements. So they already have it, but if they ask for the 9 and the 28, we give it. We're not going to complain about it. But that's why they like it, because it gives them that coverage over that encroachment. Also, again, like I said before, we're going to look to see if is there room for both. Can it be serviced? Can it be continued for its purpose with respect to the easement, even though we are encroaching in some shape, form, or fashion? Now, obviously, the bigger the numbers that are involved, higher the risk. So worst case scenario, we're going to say, okay, you've got to go back to the utility provider, whoever it is that has this easement, and get an agreement, right? Either an encroachment agreement or some sort of acknowledgement that they're aware and where your location is does not impact their ability to use their easement. That is our assurance that we're not going to be faced with some sort of really expensive claim. What I will also kind of throw out for you is that occasionally, if you work on a transaction where you have a construction, and when you do the closing to begin with, it's vacant land, then they're going to come back and they're going to ask for an endorsement to their policy once the construction is completed and they've got an as-built survey. That is becoming another extremely popular lender request. So what I have seen recently is there has been a rash of construction where there was an easement, there was a survey, there's knowledge that there are easements in various places on the property, construction gets built, and for whatever reasons, there are now encroachments. So when the lender wants to endorse their policy and bring their coverage forward to reflect their new as-built, now we have a problem that we did not have before. And so again, there are ways that we can address that. We'll probably want to go and get the containment letter or the encroachment letter from the utility provider. Or we may, who knows, maybe we'll say, okay, get the builder to give us an indemnity because they did it. They screwed this up. Let's make it their problem, okay? But we have some ways to work around that. But that is something that I have seen quite a bit of recently. All right. Now I got to go back because I forgot what I skipped. Okay. We'll come back to that in a minute. All right. Some of the other requests that come up that can cause delays to your closing are things like usury endorsements. If we're having trouble really figuring out what the lender is asking as far as what their usury rate might be. Obviously with mineral rights endorsements, we talked a little bit about that a few minutes ago, but the 35 endorsement, what that does, what coverage it gives to the lender or the buyer is again, it's enforced removal coverage, right? So basically it's saying that we're going to ensure that even if there is someone who has mineral rights that they are going to invoke, that we will cover them against loss or damage to their improvements because of the use of that mineral right, okay? So for us to be comfortable giving that coverage, we're going to want to know what's going on around this property. Is there mineral development within a 5-mile radius? Or does this property touch a school? Does it touch a church? Does it touch residential property so that the likelihood that they would be allowed to come do surface mining is slim to none? We might ask that the local zoning authority give us a letter that says that surface mining is not allowed where this property is located. So there are a variety of ways that we can get comfortable giving the coverage without requiring a mineral search. So again, sometimes when these requests for these endorsements come in at the last minute and you have no way of being able to do a mineral search and still preserve your closing date, the Alta 35 endorsement may be the way to address that and get them comfortable with coverage. And we may be able to, get those other pieces of information, the zoning, where it's located, and the level of mineral activity in the county a lot faster. So it's a way to, again, preserve your closing date, get your customer happy with the coverage, and not have to stop everything and go search back to the patent. All right, let's see. For those of you that have to deal with zoning endorsements, the one thing that I will say about that is the 3.1 covers, basically we're ensuring, it's a double negative endorsement, which I hate, but it says that we give you coverage in the event your property is not zoned industrial and that the use of your property as a manufacturing facility is not allowed, okay? So obviously we need something from the local zoning authority that confirms those things. But the zoning endorsement also gives coverage in the event that there are violations of zoning regulations concerning parking, height of the building, square footage of the building. If you go and ask for a zoning letter, most of the time they're just going to tell you what it's zoned and that whatever you're doing with the property is an allowed use. They don't address those other things. I'm going to say probably 70% of the time, we don't ask about it either. You give the endorsement, we're not going to get any issues. But for those that work on pretty significant commercial transactions, they will get what they call a PZR. So it's a professional zoning report. And that typically does go into all those details. And that's generally where we see there are violations, because there are supposed to be 55 parking spaces and they have 53. So that doesn't mean we can't give the endorsement. But what we'll do is we'll modify to take out parking. Or we may add to the endorsement that we are not taking on the expense for that open violation. And we'll put that into the endorsement. But again, it allows you to continue on, you get your closing, and you don't have to go do some sort of zoning mediation and figure out a way to add 2 parking spaces in. So there are ways to address the mess. Okay, so moving on. Search reveals that Keith Urban is the buyer with no marital status shown. Closer knows that Mr. Urban is married, but he is not yet divorced. On a purchase money mortgage transaction, does the non-titled, soon-to-be ex-spouse need to sign? No. All right, we all know this. What has been coming to light recently is we have a situation where you don't know that they're married at all, and they come in and they're doing a refinance, and then you find out they're married, but they don't live together. We've been married for years, but we have that marriage that we're just good if we don't share the same space. And I really like her being in my business, so I don't want her to know about this. So obviously, y'all, we can't do that here, right? If they're married, then they are endowed with legal rights to the property. And I actually have had a situation come up not too long ago where there was a spouse that was able to claim dower rights, much to the chagrin of the kids from the first marriage who were not happy that she had any right to this property whatsoever. And, we were like, well, sorry, we didn't create the law. So that's an issue. So I think sometimes we want to accommodate our customer, and we may, quite frankly, understand and appreciate they feel the way they do. But again, we sitting in here did not create the law. So we have to address it. So as long as that law is still in place, yeah, Miss or Mr. whoever that doesn't live together have to sign. Another issue that I've seen coming up a lot lately has been foreclosures. We had kind of a period of time where we didn't see many, and they have begun to crop back up over the last year. Thing to remember is that UCCs may not be wiped out by a foreclosure of a mortgage. You've really got to pay attention to the collateral on the filed UCC. An example, you have a property and the UCC is filed on the HVAC system. Now, it was filed 6 years after the mortgage that was foreclosed, so it is certainly subordinate. But the collateral for that UCC is arguably something that can be removed. So it is not wiped out by the mortgage, for the foreclosure of the mortgage. And instead, that creditor has to be addressed. Now, most of the time, they're not going to come pull the UCC, they're not going to come pull the HVAC system. I have seen them do it, but most of the time they will not. So it's possible that they may be willing to take a policy with an exception. But if they're not, you're going to have to address the UCC and figure out what way that can be released. And a bank, typically, who has foreclosed is not going to be happy about having to pay off the UCC, right? But again, you did not create the facts, right? The facts are what they are. But that is something to be concerned about. Also, the IRS, fortunately for all of us, they have, they subordinate themselves to purchase money mortgages, and there's a lot that we can do with them, but they have very specific requirements for notice, and if they're not properly noticed, they're not wiped out by the foreclosure either, and they pay attention. They are creditors that do watch out for their interest. So be careful and cautious when reviewing a file where you might have a foreclosure in your chain, and just double check those things and make sure that you are not faced with a situation where it may absolutely cause your closing to come to a screeching halt while you have to go and address those. And if you have one where there is a small business administration loan, they have oh my gosh, I just went blank. What's the is there a redemption period like a year? The SBA loans? So 1 year. So if you have an SBA loan, you have to address that. So they have a 1 year period in which they can come back and redeem after a foreclosure. So if you are insuring a property and the foreclosure was just 2 months ago and there was an SBA loan that was a subordinate lien, it's still a problem. And so you would have to make a note of that, or take an exception for their redemption period, or address that in some fashion. So again, we haven't seen many of them for a while, and so I just wanted to kind of bring these things up and refresh, because we're seeing quite a bit of them recently. All right. This is another question that comes up a lot. You've got a situation where you've got to do an affidavit of heirship, and everybody's related. So we get this question all the time. We're like, can we take an affidavit of heirship from someone who is related to the person? Yes, as long as they're not directly benefiting from your transaction. So if they're a sister-in-law or a mother-in-law, and in some cases, maybe even the husband of a sister-in-law or something, that's okay, because they're not directly benefiting from the closing. They're not going to be paid money out of the process. So it's okay to do that. Now, the last little point I'm bringing up, in Arkansas, obviously, most of the time you're going to have had a probate of the will, right? But every once in a while, we find a situation where there was a will, they didn't probate it, we're outside of the claim period, so we can do an affidavit of heirship, but the heirs in the will are different from the people that take at law, right? And often the problem with that is that the ones that are in the will are the ones that want to be identified as the heirs. And they don't want the others who are heirs at law to be in there. And you don't have an option, right? If they're choosing to do the affidavit of heirship route, it's intestate succession. So if they didn't want their brother who was a deadbeat, or the sister who has disappeared, nobody knows where she is, to be involved, well, then you're going to have to go to court, right? And that certainly could slow your closing down. But that is, we had a situation a few years ago where affidavit of heirship was done, identified son and daughter. And in this particular case, that was what the will said. They chose not to probate the will. The affidavit of heirship was done by their next door neighbor who had known the family for 20 years. Son and daughter, that was it, all good. 9 months later, little brother, who had disappeared to Colorado to find himself and had been lost for 28 years, finally learns through social media that mom died, and probably mom died with some stuff, right? And he shows up and was like, well, I know mom would have left something to me. I know she would have. I mean, there's just no way. And now we have a situation where we have a valid affidavit of heirship, right? The person who did it didn't lie. It wasn't fraud. But because they didn't probate the will and they chose to go through the intestate succession, now they've got this guy that's got an interest. So they had to go back. And in this particular case, they gave him some money and he went away and they got a deed from him. But, you never know. So be careful and really ask the question. If that situation comes up and there's a will and it identifies, a couple of folks, when you're asking the affidavit of heirship question, you always really need to be specific. How many kids did your mama have? Don't ask who the surviving siblings are. Don't ask who, because, and don't even just say who the siblings are, right? because they don't claim him as a brother. So if you ask me who my siblings are, I'm going to tell you my sister. I'm not talking about him. He doesn't exist. Well, but you got to ask, how many kids did your mama have? Because then, and you may find out there was one that died before, but he had a kid. But again, he was the deadbeat and they don't recognize that kid. But when you're building an intestate succession, whether they like it or not, they've got interest. All right. So I talked about this before about don't forget to read, but it is unfortunate that we go fast in what we do. And we had a situation, one of the first year or two that I was an underwriter, I got a phone call from an agent who was irate. And he said, I need you to be in my office tomorrow morning. I need you to bring the title file. And I need you to explain to me why you did not tell us that there was a right of first refusal on this property that we just closed for one of our senior partners. You need to be here 9 a.m. So I said, okay, great. I'm like, what did we do? How did we mess this up? So I go look at the search, look at the vesting deed, and I mean, in the first paragraph on the vesting deed, it flat is there. Subject to a right of first refusal, the developer of this lake house property. So I go to the meeting and I walk in and the agent is hopping mad. He's got the big vein popping up in his neck and he's red-faced, and he had an associate with him. And I sit down and he goes, okay, let's hear it. What's this explanation? Because y'all are going to fix this. And I said, well, but can I ask a question? He said, what? And I said, are you talking about the right of first refusal that's in the vesting deed? I mean, it's in the search. And he snatched the deed out of my hand and he looked at it and he goes, and he puts his hands down on the table and he takes a deep breath and he goes, Staci, your presence is no longer needed. Please leave. And I was like, oh. And the poor associate that was sitting at the table with him had examined title and he didn't read the deed, right? So ever since that, I'm like, okay, y'all, just take a moment and read. We see that these rights of first refusal or options to purchase get missed a lot. We also see that sometimes people call out an exception for them, but they've actually already been satisfied. So you really have to read and then see. I mean, if the option to purchase was just for the first sell out, and you're 8 sales down you don't need to worry about that anymore. It's been satisfied. So a lot of times when we get questions about that, what can we do to remove this? They want this exception removed, and I'm like, well, it shouldn't even be there. You're good. Or they didn't satisfy it, and now how do we fix it now? We've got to go find these people. What do we do? I have one right now where the option to purchase was held by a limited partnership. That limited partnership has been dissolved. It doesn't exist anymore. The property, when it was sold by an entity who was the general partner of that, and it went to another entity. And that entity is now the one that is offering to sign a termination of the option. But you got to put all the steps together. It may be okay, but from the recorded language, it doesn't appear as if anyone other than that original entity that doesn't exist anymore has the right. So there's a little bit of homework you have to do on those. But as a general rule, the risk is relatively small, and we can work around it. But just again, remind everybody to read. So we are all very fortunate that we have the mutual indemnification agreement, and we put that in place years and years ago to address common things that show up, right? Unreleased judgments, unreleased mortgages, a variety of little small minor things that we just see as a commonplace. And I think, unfortunately, sometimes there's a misunderstanding about the MIA. It doesn't address everything. So, for example, you may get we get a situation where there is a loan. I mean, there's a transaction and there's a missing interest, right? There's a person that never signed a deed. but they've got an owner's policy. So they send that to us and they say, but we've got an owner's policy, so we can go forward, right? We don't have to address this anymore. Well, that's not necessarily covered by the mutual indemnification agreement. So we have to really look in the situation. And well, we may be able to say, okay, yes, we will agree to do that, but we want an indemnity letter from the other side. And we're all really good about, trying to make those work. Because again, we understand we want to keep the process flowing. We don't want to stop your deal. We want you to be able to keep your closing date. So Darren, Wes, we work together and we make sure we figure that out. So, but just as a recap, the MI will cover things like, okay, if there's a homestead interest of the spouse that maybe wasn't addressed, an unreleased judgment lien, federal tax lien, or state tax lien, a prior unreleased mortgage, as long as it's not a line of credit, that has a different little attitude that we have to address. Failure of due process to be afforded to certain defendants in court cases involving probate, foreclosure, quiet title, or other proceedings. The lack of an authority of a trustee or an attorney in fact. So if you've got a situation where there was an attorney in fact that's signed, but they didn't record the attorney in fact, that is something that we've agreed to address in the mutual indemnification agreement. And then the lack of the authority of an executor or an administrator to convey the title. So if you've got a deal where somebody signed as administrator of the deed, but they weren't actually authorized so to do, again, those are things that we'll cover. So technically, you should always call us and make sure that we're good with that. Oh, shoot, sorry. In some cases, there's a limit, right? So if it's an unreleased deed of trust and it's, as of right now, $250,000 or less, we will agree to allow the MIA, and we'll just say, yeah, you're good to go. But if it was more than that, then maybe we would still be agreeable to move forward with, but now we've got a letter of indemnity we need. And whoever the insured or the insuring underwriter was, we let them know because they may want to stop the bleeding. So whatever the issue is at that point in time, we may want to go ahead and start a process of a claim or whatever it might needs to be done to fix it. Because the other side of this is, with all the curative measures and things that we have to be able to keep your deal going forward, we also always need to keep in mind, is it the best for your insured, right? We may be able to blur over whatever this is, but is it something that's going to continue to cause them a headache in the future? Are we doing them a service by still kicking the can? Maybe we are, but if it is something that potentially could prevent them from being able to have a smooth refinance or be able to sell the property, you have to discuss with them, here's what's happened, here's what we're going to do, this will allow you to close, you're going to have an insurance policy, but you need to know it may potentially still be another issue. Like, for example, if it's an unreleased mortgage and it's not going to expire for another 12 years, is it going to keep coming up? Some of the governmental lenders like VA and Fannie Mae and Freddie Mac, a lot of times they won't allow us to rely on a previous policy or insure over. They want it cleared. And so it could prevent them from being able to do a loan closing. So you do still want to be upfront with your customer about whatever the curative measure we've done if it's not completely resolving the matter. All right, church deals. All right, so sadly, we live in a world right now where the church congregations tend to be getting smaller and smaller. People don't like people these days, y'all, and they want to watch online, and they don't want to, be in the sanctuary anymore. So we have lots of church congregations that are consolidating and selling property. And I will say I've been working on tons of church deals over the years, and I feel like every time I do it, it's just another black mark against me that I'm going to have to talk to St. Peter about one of these days. One of the worst, we had a situation where a church ended up with a not so savory pastor who decided that the church funds were to be used for the betterment of his life and his lifestyle. And he used the offering plate to pay for a lovely Cadillac for himself and his wife. They took lavish trips. They had one of the biggest houses in town. And the founding families of that church wanted to get him out. But the bylaws for the church said that once the pastor had been appointed, he could only be judged by God. And there was no way that they could vote him out. So, being the enterprising and smart people that they were, they knew that the church had a mortgage. And so these 5 families got together and they said, we're not going to tithe. And we won't have enough money to pay the mortgage. And then the bank will foreclose. And then we'll work out a deal with the bank to buy the church property back. And that is what they did. And I got asked, would I insure it? And oh, by the way, they scheduled the foreclosure for Christmas Eve. I'm like, really? You couldn't postpone until January or something? But the bank wanted it off their books for that year, and that's the date that it fell on. The challenge with church properties is that they are possessed and owned by the congregation, right? A lot of churches over the last probably 2 decades are business savvy and they have created their own organization. If it's an organization, it's an LLC, it's a corporation, obviously we have procedures to deal with that, right? You get good standing, make sure they're in good standing. They've got bylaws for the corporation, or they've got operating agreement for the LLC. You make sure you follow all those things, you're good to go. But a lot of them are what we call unincorporated associations. They're allowed to be legal by state law. But when you ask them for the organizational documents, they don't have a whole lot, right? Their purpose is to serve God. Their purpose is to, they don't have a lot that you can follow with respect to who has authority to take action on behalf of the church, who's authorized to sign deeds or mortgages. There's a lack of documentation. So the thing you have to remember is, again, it's the property and possession of the congregation. So we have to get someone to give us some information about, what's our congregational vote? What is your congregation made up of? Do you have 150 members and you had a vote and you had 130 that said yay? Well, great, we're good, we'll go on with that. Where you're going to get into a little bit of trouble is that a lot of these smaller churches, again, like my first story, they're predominantly all a handful of families, right? So we had a situation one time where everything that was coming to me was signed with someone with the last name of Walker. I had pastor whose last name was Walker, the head deacon's last name was Walker, the treasurer's last name was Walker, and everything they were sending to me, I was like, is there one person not related to the Walker family that I could get something from? Because we do have claims on church transactions, and typically what ends up happening is there is a fraction in the church. One group wants to sell, one group wants to keep going. The group that wants to sell says, we don't need you. And they go through the whole process, they sell, they get the money, and then the faction that didn't agree files a lawsuit. It gets messy. So you have to be really careful with churches, because there aren't going to be, in a lot of cases, clear cut, here's what you have. Now, there are some that do. So I kind of put a list up of the church denominations where we know they have really good, clear direction. This is what has to happen to sell or encumber specific properties. And that's helpful. And if you take nothing else away from today, but definitely keep this information, because that gives you some direction. The other challenge with church property is that even if you don't have an issue with the organizational documentation, what you may find is that when it was property that was given to the church, it was to be used for church purposes. And if it ever ceases to be used for church purposes, it goes back to the person who gave it to the church. And you may be looking at a deed that's 100 years old. And now you got to figure out who that family was to begin with, right? So don't forget to read the document and make sure you're not dealing with that situation, because that is often the case, that when people give or will property to the church, that is their intent, is that they only want the church to use it if they're using it for church purposes. But if the church is just going to sell it, you know. Now, I will say that there are times that we have tracked down the families, and the families just say, well, the money is going to go to the church and they're going to use it for their purposes. I don't see why we need anything. That makes sense to me. And maybe you get lucky, but you do have to worry about those things. So we're going to always want like a certified copy of the minutes showing when there was an approval of the church vote to take the action. We hope that the minutes will identify who the governing party is. You know, who are the deacons, who are the elders, who are the trustees, and ultimately who has been designated out of that group to be your signatory. So we're going to want to try to put together some version of that in order to be able to approve your transaction. All right, more fun. All right, I'm gonna make sure. See, I'm already over. I knew I was gonna do that. Okay, I'm gonna wrap this up real quick. So your closing is scheduled for the morning of the 29th. On the morning of the 28th, the agent calls to inform you that she has just learned that one of the buyers will not be able to be at the closing because he is overseas. By the way, y'all, I had somebody call me and tell me that, and you know where the buyer was? They were in Canada. That is not overseas. Just a point. Okay, so anyway, but they have a power of attorney that this person signed in Germany, right? All good. You don't have to worry about that. You're golden, right? Well, hopefully, yes. But quickly, we don't hate POAs. Everybody thinks that the underwriters hate POAs. We do not. They're very valid documents. We appreciate their use. But they continue to be year in and year out one of the single largest sources of fraud. So when you have a POA that's going to be thrown on you at the last minute, which is often the case, look at the details. Who is the person that has been given the authority to sign this POA? Where are they signing? Can they come and sign one in your office so you have a little more control over it or not? If they're signing overseas, what is their connection? Why is this person overseas? And is there anything in your history of your document to show that any member of this organization or this partnership or this trust has ever been out of the country before? Because it could be a red flag, right? We have lots of ways to address documents being signed out of the country. If they're a U.S. citizen, that they can go to the embassy. If they're not, they can go to a notary in any country that is a member of the Hague Convention. If you're not familiar and don't remember that from back in the day when you were in history, it is a fabulous international agreement. And one of the provisions in this, it's a whole bunch of them, but one of them is that they have all agreed amongst themselves that documents signed in an official capacity in that country will be accepted for legal purposes in the other member countries of the convention. So that means we don't have to all go dig through AI and ChatGPT to figure out how a person becomes a notary in Botswana or whatever, okay? So we're good with all of that, but we've got to know if they are a Hague Convention country. So there is a fabulous website, www.hcch.net. And you can go to that website. It has a list of all the Hague Convention countries. And if you click on the country, it will take you to a place where a person can sign from a notary and have their apostille done. And we will be able to accept that. So that is a good source of information. I got to leave you with a picture of Elvis, obviously. If you have a military personnel that is going to need to sign, there is a federal regulation that addresses that. And so a military person can do that notarization, and we will accept that in wherever they sign. So it doesn't have to be overseas or in another state. So I have overshot my time, so I will wrap things up. But I hope this was helpful. I did want to leave you with one last little thing. If you've got FIRPTA involved in your transaction, we have had 3 claims in the last 9 months dealing with FIRPTA. So I just want to remind you all, if you have a foreign seller and FIRPTA is going to apply, get the document signed, submit it to the government, and let whoever the person is who disagrees with the amount or what, let them deal with the government and you get out of it. The claims have become where people have agreed to escrow while the parties figure it all out. And unfortunately for everybody that's involved, the government typically doesn't agree with whatever the request for the exemption is, and they will slap the buyer with fines and penalties for the delay in making it paid. And you don't want that for your buyer. And as party on the seller, you just need to explain to your seller, look, get with an accountant, get whatever you need done, but we have to submit it within 20 days of the closing, and then you can work with them to get it back. So that's it. Thank you guys.